the prescription of crimes committed here. Because we might reach a point, Mr. President, that the perpetrators might be in the Philippines, the other conspirators might be outside of the Philippines, and the period of prescription for those outside of the Philippines will start only once we acquire jurisdiction, once the courts acquires jurisdiction. So we might be placed in an administrative dilemma wherein some of the co-conspirators are already in jail and then or perhaps released, or perhaps the crime was prescribed. But for the other participants coming from outside of our territory, it will only commence once they enter our territory, Mr. President. Am I correct? So this would entail a very difficult administrative, judicial, prosecutorial proceedings insofar as our criminal justice system is concerned, Mr. President.
I think the law on prescription will apply. For capital offenses, it's 20 years. So if that does not come to our country to be prosecuted, then and after a lapse of 20 years, then the crime against him shall be prescribed. I hope I'm correct with my response, Mr. President.
Thank you, Mr. President. Thank you for the two gentlemen for allowing me to interject. I just have some administrative nuances that probably I will expound during the period of amendments, especially as regards the jurisdiction on criminal cases and the long-arm jurisdiction of our courts, if there is any, Mr. President. I'd like to thank the two gentlemen. Salamat.
Anything that will enhance this measure is of course welcome, Mr. President.
Thank you, Mr. President. Thank you for the gentleman from Cavite, Senator Tolentino.
Fronts or organizations, or we just rely on the Declaration of the United Nations, Mr. President?
I suppose it should require an act of a court in the Philippines to formalize the United Nations resolution declaring a terrorist organization as a proscribed organization, Mr. President.
Mr. President, may we know from the good sponsor that at this stage, preliminarily, do we have a listing of the said United Nations proscribed organizations? Will this include the well-known Middle Eastern fronts that this representation mentioned during the interpellation granted by the good sponsor?
You're referring to the UN list?
Yes, Mr. President.
There is a list. There's a list under the United Nations resolution of this proscribed terrorist organization.
So, Mr. President, from the answer of the good sponsor, it would now mean that even if there is a list coming from a prior list coming from the United Nations, it is not automatic, Mr. President, that knowingly becoming a member of the proscribed organizations by the United Nations would merit an offense as enunciated by the proposed law, Mr. President.
Should be formalized by a competent regional trial court, Mr. President.
Again, Mr.
To formally proscribe the... Yes, it must be brought before a court who will now formally issue an order of proscription, Mr. President.
That's my final query again, to reiterate my previous interpellation, and which I think was already answered. If the court determination would come out during that hearing, how would the accused, the member, exculpate themselves? Because the declaration probably might come out during the hearing, and the timing of his membership might be a priori, or probably it was done before the declaration of the court that said organization is station. Just last one point, Mr. President.
Hindi ko na po nasundan sa haba ng tanong ninyo.
To rephrase, Mr. President, maaari po ba kaya doon lang sa hearing ay nalaman nung naging miyembro na yung palang nasalihan niya ay is front? So how can he now how can he now
Hindi po papasok sa knowingly.
Hindi na.
But of course, kung kaya naman i-prove ng gobyerno na knowingly, then problema niya yon, Mr. President. Matter of evidence eh.
Oh.
Yes.
I thank the good gentleman and the minority
Thank you.
leader for the
Mr.
time given. I
President,
yield the floor.
may I suggest that on page 24, which
Section, Mr. President.
section 22, which includes a new section 25, that the good sponsor examine closely the paragraph starting on line 22, which says the court will schedule a summary hearing at a date and time within a 6-month period from the filing of the verified application, when the respondent may, for good cause, show that the order of prescription should be set aside. This is where I was saying that we have shifted the burden of proof to the one who is arrested, because he has now to show that the order of prescription should be set aside, rather than the government justifying why it should be maintained. So something would really, that's something that would not be acceptable as a principle of fair play and justice.
Ganito po yan, Mr. President. Yung burden of proof stays with the government. Ano? But after 72 hours and the judge determines probable cause for the issuance of preliminary order of prescription against the organization concerned, what is shifted is the burden of evidence, which is shifted from the government to the other party.
Mr. President, the burden on the government is only to show probable cause.
Within a 6-month period.
Yes, and therefore, that standard of proof is not that high. But then, under the proposal, you already shift the burden to the accused. Isn't it better if the order is reversed, so that within that period, the prosecution must show that indeed the preliminary order is valid and supported by evidence, rather than shifting the burden to the defendant? Because remember, Mr. President, that this is a summary hearing, and this is just for the establishment of a probable cause. The standard of evidence is very low, or the hurdle for purposes of the evidence is low, but yet the burden is shifted to the accused, Mr. President. We would like to see a revision of this proposal, of this provision, so that it will be consistent with fair play, Mr. President.
Yeah, I agree, Mr. President. I would like to cite here another jurisprudence, Corpus versus Sarmiento, GR number 45137. It says here, when a prima facie case is established by the prosecution in a criminal case, as in the case at bar, the burden of proof does not shift to the defense. It remains throughout the trial with the party upon whom it is imposed, the prosecution.
Yes.
It is the burden of evidence which shifts from party to party, depending upon the exigencies of the case in the course of the trial. This burden of going forward with the evidence is met by evidence which balances maybe as introduced by the prosecution. Then the burden shifts back, Mr. President. I'm open to amendment, or open to further improving the language under paragraph 2, under section 25.
Thank you, Mr. President.
Pero nakalagay din naman dito na when the respondent may for good cause show why the order of prescription should be set aside. So, nandun po naman yung provision na yun. But anyway, as I've stated earlier, I'm open to further improving this particular.
Thank you, Mr. President.
This is just a continuation of the suspended interpellation of the distinguished minority leader. Willingly, Mr. President.
Thank you very much, Mr. President, and once more, allow us to spread into the record our commendation to the gentleman from Cavite for exerting effort in order to amend the present Human Securities Act, which admittedly can stand improvement and would have to respond to what we have experienced in this area in the last several years since its enactment. We find this measure the most significant portion of the measure, Mr. President, is the definition of acts of terrorism under Section 4 of the measure. This is important because it defines the crime that is sought to be punished under the law. The first issue we note is that by the definition of the Terrorist Act, it includes any person. This is found on lines 20 and 21 on page 5. By this definition of any person that is punishable, that is covered by this act, this would include state actors or agents of the law. Is that a correct definition, sir?
That is a correct definition because it states any person.
Yes.
Without exception, Mr.
Yes.
President.
Is that the intention, sir? That it would include any person? I mean, it would include members of the armed forces. Just for the record.
As long as they fall under the categories as stated in the succeeding paragraphs, Mr. President.
Yes. We have to examine this closely, Mr. President, because this is a criminal act. And therefore, as the sponsor, being the former chief of the Philippine National Police, would agree, we must have a precise legal definition. Otherwise, the police agencies would find difficulty in providing the kind of evidence to the prosecutor in order to prosecute the crime. Now, in international law, there is yet no precise definition of...
That is correct. There are at least 10 definitions. As a matter of fact,
I'm sorry?
there are at least 10 definitions of the terrorism, Mr.
From my
President.
readings, there are about over 100 definitions.
Okay, over 100.